Welcome to Planet Lex, the podcast of Northwestern Pritzker School of Law, bringing it to you from Chicago, Illinois.
Hello, and welcome to Northwestern Law's Planet Lex, podcasting from the Northwestern Pritzker School of Law in Chicago. I'm your host, Vice Dean Jim Speta. Joining me today are two members of the Roderick and Solange MacArthur Justice Center in our Bluhm Legal Clinic. David Shapiro, director of the center's Supreme Court and Appellate program and a clinical associate professor of law, and Daniel M. Greenfield, the center's solitary confinement appellate litigation fellow. Thanks to both of you for coming in today.
Thanks for having us.
David first joined the MacArthur Justice Center as an attorney in 2012 and has been litigating ever since to protect civil rights in the U.S. Supreme Court, the federal courts of appeals, and state Supreme Courts. In recent years, David's argued before the en banc 8th and 9th Circuits, the Illinois Supreme Court, and numerous federal appellate panels across the country, winning appeals regarding law enforcement misconduct, the Prison Litigation Reform Act, criminal procedure, First Amendment, and deaths in custody. David has also published extensive scholarship on civil rights and has an absolutely fantastic article on solitary confinement forthcoming in the Harvard Law Review. Daniel joined the MacArthur Justice Center in March 2017 and focuses his work on appellate litigation to end prolonged solitary confinement. He was cert stage counsel of record in Apodaca versus Ramish, a case that provoked Justice Sotomayor to describe solitary confinement as a penal tomb, and has litigated successful solitary appeals in the 4th, 6th, 7th, and 11th Circuits. Prior to joining the center, Daniel was pro bono counsel at Sidley Austin in Chicago, where he ran the firm's federal civil rights litigation project and maintained an active capital post-conviction and federal habeas practice. Daniel is our alum, graduating from Northwestern Law in 2008, and also received a master's degree from the New York University Tisch School of Arts graduate film program. Now that we've finished the bios, thanks again for joining me.
Thanks for having us.
Before we begin to focus on solitary confinement, I'd like to talk a little bit, although I'm about to ask an enormous question, about incarceration in general. We've gone through several phases in thinking about incarceration in the United States. How would you characterize the use of incarceration in the United States today, generally, but keeping in mind our focus on solitary confinement?
Well, I think I'd begin with the point that overwhelmingly, incarceration is the primary form of criminal punishment in the United States today. We have a very limited death penalty, and fines certainly play a role. But really, the lion's share of the punishing is occurring through incarceration. And we have the largest system of incarceration on earth. We have more prisoners than any other country, including much more populous countries like China, for instance. And we also have the highest per capita rate of incarceration, with the exception of the small island nation of Seychelles, which has a very small population to begin with.
To add a little bit of meat to that, we have, not that that wasn't meaty, we have 5% of the world's population, but 25% of the world's prisoners. And if you wanted to think of incarceration as rehabilitative on the one hand versus punitive or for purposes of incapacity on the other hand, we are very much in the incapacitation camp right now.
Meaning after conviction, we put people in prison just so that they're not in society anymore.
Correct.
And you mentioned other possible purposes for incarceration. You mentioned rehabilitation, and you also mentioned...
Well, I also said punishment for punishment's sake, and I think that is a partner to incapacitation. But I think if you were to look at some of the Western European nations, particularly the Scandinavian countries, you might learn that they successfully rehabilitate prisoners by providing them services, education, healthcare, and really prepare them to excel in society upon release. And that is definitely not the model here. And if I can use a metaphor, I think our model is akin to taking a gun and shooting ourselves in the foot repeatedly, because most prisoners will leave prison at some point and will re-enter society, and it does not only them and their families a disservice, but our society writ large a disservice to incapacitate them and to fail to set them up for success upon release.
That's going to, I think, be a big part of how we begin to talk about solitary confinement as well. But before we get to solitary confinement, let me just ask a few more questions about the status of people who are incarcerated. Most of our notions, at least in popular culture, of criminal law, the criminal law we see on television, and in fact, a lot of the constitutional provisions on criminal law focus on protections for those who are accused of crimes, limits on the police, the right to counsel, the right to trial by jury. What about after conviction, once people are incarcerated? What are the rights of people who are in prisons and in jails serving their sentences?
I would say that there are two main changes in the status of your constitutional rights that occur when you are incarcerated. The first is that the Eighth Amendment right against cruel and unusual punishment becomes a source of constitutional regulation of your conditions of confinement, though it is a highly, highly deferential standard.
Deferential to whom?
Deferential to prison and jail administrators. The sort of dominant note in contemporary prisoners' rights jurisprudence under the Eighth Amendment is that courts lack the institutional competence, and for that reason, as well as reasons grounded in federalism, that the federal courts are unlikely, except in relatively extreme cases, to second-guess the judgment of penal administrators. The second thing that happens with incarceration to the status of your constitutional rights is that your other constitutional rights, your First Amendment rights, for example, your religious exercise rights, your free speech rights, your due process rights, et cetera, function in a very diminished way. And there again, the law is heavily characterized by the same themes of deference to prison officials and not wanting to second guess them, even though the constitutional source of the right is different.
So to come back to one of the things, Deanna, you said about rehabilitation, under our way of thinking about constitutional rights, prisoners don't have a right to rehabilitation or educational services or other sorts of services in prison. Is that accurate?
Correct. I think under current jurisprudence, they are entitled to constitutional minima, and that does not currently include rehabilitation or education unless the lack of those rights, which we would think of as, rights that belong to free citizens, push the bounds of the Eighth Amendment. If their deprivation reaches constitutional magnitude, then it is policed by the courts. But otherwise, it tends not to be.
So let's turn to focus on your recent work on solitary confinement. For those who might be unfamiliar with the ins and outs of solitary confinement, can you describe what we mean when we say that a prisoner has been placed in solitary confinement?
Yeah. In its most general sense, solitary confinement refers to the isolation of a prisoner in a cell for 23 hours a day during the week, 48 hours during the weekend. And typically it's a cell that has a solid steel or other sort of solid door on one side and maybe a opaque window on another. And so by and large, you are wholly removed from the general prison population, and you have almost no meaningful interaction with other prisoners or with even prison officials. So for 23 hours in each day, you sleep, you eat, you void your bowels, and you do all of the other things that a human being does, but you're confined within a space that's seldom larger than a compact parking space. For approximately an hour each day during the week, most prisoners in solitary confinement are afforded an hour of what's euphemistically referred to as recreation or yard. And what that means typically is that they are bound with shackles and leg irons and escorted to a cage approximately the size of their cell where they can pace around like, an animal at a zoo, or where they can do chin-ups or pull-ups, but they are not permitted to exercise with other prisoners generally. And sometimes these outdoor recreation spaces function as sensory deprivation chambers because many times they are akin to sort of a bathtub design, meaning it's solid walls on all sides. But if you peer up, you can see the sky. But these are not yard and they are not recreation in any normal sense of those words.
So even though you say 23 out of 24 hours, it sounds like there's sensory deprivation almost all of the time.
Yeah, the deprivation of environmental stimuli is an almost unvarying feature of solitary confinement. The best case scenario, a prisoner in solitary confinement is afforded access to a television in their cell, which might have limited programming on it. Often, prisoners are deprived even that meager concession and are afforded access only to religious tomes and occasionally to a non-religious or non-educational text or two. So they truly, by and large, are alone with their thoughts. Communication with other prisoners, if it's possible at all, is generally achieved by shouting into plumbing pipes or standing on their concrete slab bed and yelling into the HVAC system. So it really is, I think Justice Sotomayor's description was apt. It is a penal tomb.
Give us a sense of how extensively solitary confinement is used in incarceration today.
It's quite extensive. Statistics vary, but I think if you were to look at, say, the Lyman Center at Yale, which has done a wonderful job aggregating data over the past several years, the story would be that approximately 80,000 people are in some form of solitary confinement in American jails and prisons today. Those numbers have reduced somewhat over the past few years, thankfully, but it's still a fairly robust subset of our prison population.
What are the triggers for solitary confinement? When does a prisoner find him or herself in solitary confinement?
Well, the triggers can be broader than one might think. And I think that there is this idea that exists in the world that to be in solitary confinement, you have to be the worst of the worst. And the image of Hannibal Lecter or that metaphor comes to mind as the kind of heartland of the type of person who's going to be in solitary confinement.
Oh, I wish that movie had never been made.
And in reality, the situation is very, very different. Sometimes it can be people who engage in a series of low-level disciplinary violations. Sometimes it can be people who, frankly, are perceived as a nuisance because they're suing the prison too often, and it's a form of retaliation. Some periods of solitary confinement can be triggered for really trivial stuff. For example, Fifth Circuit upheld a stay in solitary confinement of many months because a prisoner refused to pull sticker vines on one day as part of a work detail. In North Carolina, prisoners were sentenced to long years, many years of solitary confinement for maintaining Facebook pages through contacts on the outside, contrary to prison rules. And certainly serious assaults, the rare case of a murder in prison, that'll get you in solitary confinement too, but it's not the typical case.
I want to come to something that you just said that struck me. Years in solitary confinement. How long would, I don't know if it's fair to say there's a typical, but how long can people be in solitary confinement? 4 years in some cases?
Indeed. The Lyman study, Lyman and the American Association of State Correctional Administrators study that Danny referred to, if I'm remembering the statistic correctly, it found that over 2,000 prisoners had been in restrictive housing for 6 years or more across the country. And that study defines restrictive housing somewhat broadly as 22 to 24 hours a day. But anecdotally, if you're in that kind of restrictive housing, it's more often, 23 or even 24. We had a speaker at the law school recently who spent 43 years in solitary confinement, which I believe is the record or close to it. Some stays are, 30 days for a disciplinary offense that's considered relatively minor, but many years is not only possible, but fairly common.
Yeah, and just to flesh that out a little bit, and again, this is anecdotal, and also the subset is probably skewed because we are impact litigators, but most of my clients have spent years in solitary confinement, and I've represented someone who spent 22 years. I have 2 clients who have spent more than a decade in solitary confinement. It's the rare client that I come into contact with that has spent fewer than several years in solitary confinement. And to go back to your question about why might someone end up in solitary confinement, David's answers are spot on, but I'd also like to add one more reason that I think is even a bit more pernicious, and that is people are placed in solitary confinement as a consequence of mental illness. People who suffer from serious mental illnesses understandably have a very difficult time conforming their behavior to the myriad rules and regulations that are the defining feature of prison life. And so I have clients who were not initially placed in solitary confinement, but whose solitary confinement stint was extended dramatically by virtue of the fact that they had a hard time keeping their cell organized in the fashion that was pleasing to correctional officers, meaning that all of their items were stacked in a certain way, that their trunk of possessions was not overflowing. I have clients whose serious manifestations of mental illness has prolonged their solitary confinement. For instance, when they have been compelled to smear bodily fluids throughout their cell and on their person, that sort of misconduct occasioned by mental illness can add years and decades to a solitary stint.
I want to turn to, I think, part of what's motivating the attention and the litigation that you all are involved in, which is recent research building on a long line of research which talks about the effects of solitary confinement on those who are subjected to it. So, and just invite you to start either with your clients or with the research and talk a little bit about that.
Yeah, so I think your question is framed properly because you mentioned a long line of research. And so what I think is going on and has gone on is that we have known for 100 years, for more than 100 years, that solitary confinement is deadly, is debilitating. If you were to look at early experiments in the earlier days of the Republic, which David, I'm sure, will talk about with solitary confinement, it was known that solitary confinement rendered people wholly unfit for return to the community. The famous Supreme Court case of 1890 of In re Medley, which was really an ex post facto challenge, but included some very powerful language talking about the just complete and total psychological decompensation of prisoners held in solitary confinement, and not even prisoners who were subjected to solitary confinement for the sorts of years and decades that we're talking about. So this was known. But what we didn't have was really, I think, peer-reviewed research, and we didn't have robust data sets. And that information, as far as I'm aware, started to be collected in the mid-1980s. And with publications by people like Stuart Gracian, and then later Craig Haney and Terry Coopers and Bree Williams, all, and those are just to name 4 people really at the forefront of this research, but who are psychiatrists or psychologists or traditional medical doctors by training, but have devoted much of their career to studying the impacts of incarceration generally and solitary confinement specifically, and what they can now quantify in a way that I think makes modern day courts comfortable in relying upon is the outsized effect of solitary confinement when compared to life in general population. Nobody would assert that prison is beneficial to someone's health, but being in solitary confinement is dramatically worse. And before I talk about some of the specific effects, I just want to note that about a month ago, there was a remarkable article published in the Journal of American Medical Association that looked at a data set of like 300,000 prisoners in North Carolina. And some had been in solitary confinement prior to release. The remainder had only experienced general population. And the premature death rate of those subjected to solitary confinement was disproportionate at a statistically significant degree to those who had only endured general population. And so
people who have spent time in solitary die sooner.
They die sooner. So let me talk about some of the psychological and then physical effects. And I think the psychological effects we would all expect. As Justice Kennedy memorably said in concurrence in Davis v. Ayala, solitary confinement drives men to the edge of madness, and it drives them well beyond the edge. But if you take someone who enters solitary confinement without any sort of pre-existing diagnosed mental illness, they are liable to develop and experience symptoms that we associate with diagnosable mental illness today. Deep depression, massive free-floating anxiety, suicidal ideation, suicide attempts are a frequent feature, cognitive problems in terms of memory. And then there are sort of physical, or what these scientists would characterize as physical symptoms of solitary confinement. And they are, with advances in brain imaging and brain chemistry studies, we now know that structures and substructures within the brain increase and shrink in reaction to isolation. So, in other words, solitary confinement is inflicting physical changes on the human brain.
Causing brain damage.
Like, we wouldn't hesitate to say that traumatic brain injury is a quantifiable physical injury, and solitary confinement is much the same. And then there are also physical side effects and physical injuries that arise as a consequence of solitary confinement that I think we would also all expect, that we know to be true. A sedentary lifestyle in a confined space is likely to lead to arterial sclerosis, diabetes. So it is both psychologically devastating and physically damaging. And what's more, the leading experts would say, and their data bears out, that these impacts may be irreversible and probably will impact the average survivor of solitary confinement until the day they take their last breath.
So does this map onto a constitutional argument that solitary confinement, it violates the Eighth Amendment? Is that the shape of the litigation, or is the litigation shaped in other ways?
So, I mean, that is certainly a primary, if not the primary argument, is that solitary confinement amounts to cruel and unusual punishment in light of the psychological and physical injury that it inflicts, and the fact that those inflicting that injury are well aware of the likely outcome of what they are doing. There are other constitutional challenges that we frequently raise too. Many of our cases include procedural due process challenges under the 14th Amendment, which look at the process afforded prior to the imposition of solitary confinement and the periodic process offered throughout the maintenance of solitary confinement.
So what's the receptiveness? What's the state of play? You've referred to a few very important Supreme Court cases. What's the state of play in the courts more generally?
So I think any answer to that question must start with the Supreme Court, and with Justice Kennedy's retirement. It seems unlikely that there are 5 votes in the usual would be 5 votes that could be marshaled in the usual case to hold that solitary confinement violates the Eighth Amendment. So the focus of our practice right now, by and large, is on the lower federal courts, and my practice specifically on the federal courts of appeals. And there, I think we are making significant progress. We have, over the past 2.5 years, as you mentioned in your bio, obtained a number of appellate victories, including in courts when with panels where one might not expect that. And even when we've lost, which is once in the 10th Circuit and once in the 8th Circuit, the 8th Circuit petition for rehearing en banc is now pending. Even in losses, we've had a split decision where the concurring or dissenting judge has written movingly about solitary confinement and the harm it inflicts. And just recently in the 8th Circuit, Judge Erickson, who is a recent appointee, a Trump nominee, wrote that while he felt that he was bound by existing precedent to hold that defendants were entitled to qualified immunity in an Eighth Amendment and procedural due process case, that it was long past time for the Eighth Circuit to revisit its prior precedent in light of what we now know about solitary. And he said that holding that solitary doesn't implicate constitutional protections is akin to ignoring the science. And so I think that thanks in large part to the work of these researchers, even judges who are not predisposed to be sympathetic to prisoners' claims are finding it very difficult to look away from what is obvious, that solitary not only impacts prisoners in unconstitutional ways, but I think debases us as a society.
It's an interesting idea, the social context of it, because as you referred to, we've had solitary confinement for a long time, and this is something you've been writing on, David. How do you see the current practices of solitary and the current research and thinking about solitary within the long historical context of incarceration in the U.S.?
Sure. To sort of sketch the history in broad terms, yes, it's true that we've had solitary confinement for a long time. It's also true that in some respects it is a relatively new phenomenon. And what I mean by that is that there were experiments with solitary confinement from the earliest years of the Republic, and it briefly came to be a widely accepted and highly favored form of incarceration in the early 19th century. And indeed, it was viewed as humane. It was perhaps in relative terms in the sense that it replaced the death penalty for a large number of offenses. And the idea was that people would be redeemed through isolation and severe introspection and repentance as a result of coming to terms with what they had done and being forced to do that in near total isolation. It didn't work out so well in practice, and some of what Danny mentioned alluded to that. So even in the 1840s, Charles Dickens comes and visits Eastern State Penitentiary in Philadelphia, and
the Charles Dickens.
The Charles Dickens, yes, not Charles Dickens the butcher, but the Charles Dickens, and writes quite memorably about the torture on the mind that solitary confinement inflicts. Alexis de Tocqueville, and yes, that Alexis de Tocqueville had a similar reaction when he visited a solitary confinement prison. And this quickly became generally accepted, as Danny mentioned, by the late 19th century. The Supreme Court is noting that solitary confinement drives people to insanity. And so it ceased to be an acceptable mode of punishment and was abandoned except in very, very rare cases until the 1980s when it was the tough on crime era in the United States. There was a perception of social disorder as well as that same disorder mirrored in prisons with some prison uprisings in the 70s as well. So solitary confinement came back, and that's what I meant in the sense that it is a new phenomenon. In that regard, it had been all but extinguished for the vast majority of our history, and since the 80s, it has expanded exponentially in tandem with the exponential expansion of the prison population as a whole.
You recently organized a conference together with our law review on solitary confinement, which brought in politicians, former prisoners who had been subject to solitary confinement, academics. Is this a sign that we're in a particularly interesting time, even apart from the litigation that's going on? There's a discussion. I know Danny said one of the dissenting or concurring judges in the Eighth Circuit was a Trump appointee. There is some concern across the political spectrum, from the left to the right, about over-incarceration. Are there other reform efforts going on with respect to solitary confinement, or that should be going on with respect to solitary confinement, apart from the litigation work?
Absolutely. There is, in many, many states, reform going on at the legislative level as well as at the corrections secretary level that is reducing solitary confinement, is reducing its use in particular for particular populations, although everyone is affected by it. People who may be especially affected by it, such as children in juvenile detention, pregnant mothers, people with mental illness, people with severe disabilities, etc. And it is, to be sure, incremental change, but it is also meaningful change, and change, I think, that would have been unthinkable, politically speaking, without the new science that Danny has referred to, or the new scientific confirmation of what was known in the 19th century, and a renewed focus on solitary confinement in popular discourse, even the press, etc. And one of the speakers, one of the goals of the symposium that you mentioned, Jim, was really to bring together from all sorts of different disciplines and persuasions people who are interested in curbing solitary confinement. And so we had corrections administrators, we had Senator Durbin, who's introduced federal legislation to limit solitary confinement, psychologists, lawyers, medical doctors, law professors, of course, including ones focused on the original meaning of the Eighth Amendment. And to your question about reforms, Leanne Birch, who's the director of the North Dakota Department of Corrections, was one of our keynote panelists, and she has absolutely dramatically reduced the solitary confinement population in North Dakota, and in fact has changed the face of the form of the housing, even for the people who need the most attention and security, so that it really is difficult to call solitary confinement at this point. So yes, there is lots of serious change going on and lots of work to be done.
You spoke, Danny, about strategies for change. What is your perspective looking forward?
So, I mean, I'm limited in what I can do as a lawyer. I can find good cases and write a good brief. But what I think is most persuasive to the court in these cases is hearing from diverse and unexpected voices as amicus curiae about the harms of solitary confinement, the lack of utility of solitary confinement. So I think your listeners might be interested to hear the list of amicus briefs that were just filed in support of rehearing in that Eighth Circuit case, because some of them are quite surprising. Of course, there is the brief of the scientists setting forth the psychological and physical injury. Less expected is the fact that a group of former high-ranking Department of Corrections officials from across the country, from many states that we don't associate with liberal prison policies, filed an amicus brief saying, essentially, solitary confinement doesn't make prisons safer. To the contrary, it makes prisons more dangerous. Solitary confinement is expensive, and there is no reason for solitary confinement because for the very small subset of the population that needs to be kept apart from the general population, the, mythical Hannibal Lecters in this country, there are ways to keep people apart that are also humane. You can keep them outside of the general population without isolating them totally from humanity. Even more surprising was the fact that some 40 former Department of Justice officials, voices as diverse as Michael Mukasey, who was Bush's AG, and Neil Katyal, who was Obama's Solicitor General, signed a brief on behalf of prosecutors saying, solitary confinement makes our jobs more difficult. Number one, it causes recidivism. Number two, our mission is to do justice. We can't face the public and say we are justice-oriented individuals when we know that the criminal sentences we advocate for will result in the imposition of cruel punishment upon subsequent to conviction. And number three, and this is something I had never thought about, peer nations are unwilling to cooperate with us in law enforcement because of our imposition of solitary confinement. For instance, if we want to extradite a suspected high-ranking terrorist from a Western European country, they may not send them over to us because of the threat of solitary confinement.
Wow, that's a really diverse group.
Yeah. Oh, yeah. And the list goes on. So there are people in broad areas of life in this country who share this concern, and I think their voices, more than any lefty lawyer's voice, are the most important to this battle.
Well, thank you for sharing this primer and insight into this current important issue. For those of you who are interested in reading more about it, you can read David's forthcoming work in the Harvard Law Review. The Northwestern University Law Review will be publishing the results of the symposium. Danny's cases and David's cases are regularly covered in the media because these are really the important issues of our time. So thank you again for coming in today.
Thanks, Jim.
Thanks very much.
Well, that's our show for today. Thank you out there for joining us. If you have liked what you have heard, please subscribe and rate us on Apple Podcasts. I'm Jim Speta, signing off from the Northwestern Pritzker School of Law.
If you'd like more information about today's show, please visit law.northwestern.edu/planetlex or legaltalknetwork.com. Subscribe via iTunes and RSS. Find both Northwestern Pritzker School of Law and Legal Talk Network on Twitter, Facebook, and LinkedIn. Or download the free app from Legal Talk Network in Google Play and iTunes. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by, Northwestern University, Legal Talk Network, or their respective officers, directors, employees, agents, representatives, shareholders, and subsidiaries. None of the content should be considered legal advice. As always, consult a lawyer.